Max now works extensively in the fields of arbitration, ICT/technology law, and intellectual property law. He is the International Chamber of Commerce Young Lawyers Young Lawyer Arbitrators Forum ICCYF representative for Africa, and is listed on the panel of neutrals of the Lagos Court of Arbitration and the Federal High Court of Nigeria ADR Center. Max is a notary public and a member of the Chartered Institute of Arbitrators UK and International Bar Association. I hope that you found the various sessions of the handholding series informative, and I'm sure that you will find Max's presentation very educative too. It is my pleasure this afternoon to invite Max Ikomwe to take the floor for his session. Thank you very much.
Thank you very much, Chairman, and good afternoon, everyone. It's indeed a great pleasure and a privilege to be here this afternoon to just try to take us through a few things I think are areas, emerging areas. I mean, we're not touching too many of them, just a few of them that I believe are relevant to young wigs who are just getting into the profession. I must particularly commend the MBA ICLE for this hand-holding series. I think this is absolutely important because when I was called to the bar, I mean, it took me maybe 3, 4, 5 years to really understand a lot of the things I've already heard a lot of the speakers present to you in the course of this hand-holding series. And what that has invariably done to a lot of us who were called to bar in those days where we didn't have these kinds of opportunities was that it took a longer time for people to understand what the profession they had been called into was all about, to find their feet and to begin to make a headway in the profession. So I think having this early on in your practice career is absolutely important for you. And what I would encourage each and every one of you to do is to really take this series very important and allow this series to be an opportunity to make you begin to think about what direction you want to take in the profession, because knowing that direction early enough, I think, is important. It helps you to avoid a lot of the mistakes that, I would say some of us made when we got into the profession. And then that way, you are able to get yourself into a position where you quickly are able to fulfill what your desires are in the profession and, of course, achieve your goals. I hope you can see my slides. So I have slides there, and because we're having Justice Dingba present after me, I'm also in a hurry to hear Justice Dingba. So I'll try to get through this quite quickly so we can get to hear, some, because I mean, Justice Dingba for me is quite a legend. I mean, somebody who rose all the way to the top of practice, so far as I'm concerned, in one of the top law firms in Nigeria, and yet left all of that to become a judge. For me, I think that is really great, and it's somebody we should all be anxious to listen to, because he has seen both sides of the coin at the highest levels and will be able to give us a lot of insight. So this is my brief outline for today. We'll be looking first of all at, we'll be starting with just an intro, just to orientate us about what modern legal practice has become and the fact that it has become really huge business. It's no longer the vocation it used to be in those days. And then, of course, we look at some of, we ask ourselves the question, these emerging areas, what essentially are there? I choose to define them as a blue ocean strategy. I'll explain more about that. Then we'll look at some of these emerging areas, the ones we are going to be focusing on today, 3 of them, and then some of the advantages of practicing in these emerging areas rather than crowding into the space where everyone else already seems to be. And then how to establish a practice in an emerging area. So we'll try to do some trend spotting and understanding the evolutionary circles that produce these emerging areas, and just to help us understand how to gain that first mover advantage. Then also it's very important because when you talk about emerging areas, there can be a lot of buzzwords and a lot of fads. They are just trendy, but there's no value in them. So you need to understand how to vet and know, where there's solid value and how to build upon that value. And then we'll also look at what's at the core of practice in some of these emerging areas. What is it really? Is it old knowledge? Is it new knowledge? Is it specialized knowledge? You just need to make that distinction. Then, of course, how to acquire knowledge in this area. I remember during the last session, a couple of people were asking questions about, online courses and books. So I've tried to come with a couple of links to online courses and books that I believe would help you in some of the areas we'll be talking about today. Then we'll look at a brief overview of some of those emerging areas. So if you notice the way my outline is presented, we are spending actually spending more time, on understanding what these emerging areas are and how to get into them than we'll be spending on discussing those new areas themselves. And this is intentional because these new areas are, of course, also very broad. We would need a full training to actually unpack what practice in those areas really entails. But I'll just touch, the overview. I mean, of course, the way the popular saying goes, it is better to teach a man how to fish than to give him fish. So what we are trying to do with this session is just to open your eyes and help you know how to begin to spot these areas yourselves much more than just teaching you the nitty-gritty of those areas. Like I've said, there will be a couple of recommendations of books and online courses that could actually give you the core knowledge you need in those new areas. So modern legal practice is big business. Of course, this is a picture of our dearly beloved lawyer's robe. So, there's this funny looking thing at the back of the robe. It's called the Leary pipe. And some of the legends, the story behind it is that before now, I mean, when the legal profession emerged in common law in the UK, the idea was that lawyers were not supposed to sue for their professional fees. So it was almost considered that legal practice was a vocation, was a calling, just like being a cleric, a pastor. So the idea was that you were not really, in that sense, entitled to demand payment for your services. You were doing, as it were, you were serving the cause of justice. So the idea behind that thing hanging behind our wig and gown was that it was supposed to be like a bag that had two compartments. So one was for silver coins, one was for gold coins. So the idea was that while the lawyer was making making submissions in court and impressing his client will reach out behind him and drop a little token, just like the offering that men of the clergy take now. So you can imagine where we are coming from. This was a time where, of course, there's some argument to say that is not exactly what that what it represents. That rather is just a fashion statement, that has stuck along with the profession up until now. But however, be the case, what it just tells us that there was a time when legal practice wasn't such a big business like it is now. It was a time where it was considered a vocation. And not too long ago, when I was called to the bar in 2008, it was still a hot argument whether law was a business or a vocation. A lot of people would think you were heretical if you said law was a business. They thought, no, it was just a vocation, it's a calling and all of that. But we have seen that the numbers have told us otherwise now. So this is just to give us an idea of the scale of how huge business law has become. Law firms now gross revenue like mega corporations anywhere. So this is just a table I took. These figures from 2019 that shows us some of the highest revenue earning law firms in the 2019 financial year. Icle and Ellis is a US-based law firm. So you can see their revenue they brought in 2019, $4.154 billion US dollars. They have 2,598 lawyers under employment, and the revenue per lawyer, that means each lawyer notionally brought in $1.5 million US dollars. The profit per partner was about $5.1 million. So you can see that list. So it tells you, I mean, this clearly is not a vocation. It's not somebody waiting for clients to drop coins at the pocket behind him while he's making submissions in court. These are guys who are charging, an arm and a leg. So this just to help you, let you know that, look, when you think of legal profession, think of a profitable business. It's not just a mere vocation. There is, of course, some regulation to how the business is run, but at the base of it, it is a business and it should make profit. So I'm just trying to update that now. These are more recent figures from 2022 from a website called Above the Law. Same Kirkland and Ellis is still topping the chart now with $6 billion in revenue, Latham and Watkins, and a few others. So like I said, this is just to help us visualize the kind of profession we are coming to. So don't have low expectations. I mean, the Nigerian legal profession, unfortunately, is not anywhere listed here. And because most Nigerian law firms run very tightly knit businesses, we might not be able to get figures to really know what the revenue for law firms in Nigeria is like. But I can assure you also that Nigerian law firms are also, grossing a lot of revenue at the moment. So just a few fun facts from what I've presented. Now, number one is that most of these law firms that we have mentioned that you have seen grossing billions of US dollars. They also play actively in these emerging areas of practice that we're talking about today. Then there was something mentioned there, if you notice on the first slide, that mentioned that some of the law firms are what we call Swiss Vereins. So Verein is simply Swiss word or a German word for association. I just thought it was important to mention this so that you understand how some of these law firms have grown so big, how they have, I mean, one of the law firms you saw there, Dentons, has 8,000 lawyers, and I think even more, maybe 10,000 by current figures. A Nigerian law firm also is part of that association as well. So the Swiss Verein is a type of corporation under Switzerland law. It's like incorporated trustee in Nigeria. The difference being that, unlike incorporated trustee in Nigeria, it could also be used by commercial, associations that have commercial purposes in mind. So it's a loose association where such law firms maintain their independence within their jurisdictions. So there, for instance, a Nigerian law firm is not, allowed by our rules to share profit with an international law firm or international lawyer. So with those firms operating as Swiss Vereins, they avoid breaching that rule, so they can localize profit sharing while maintaining that international synergy. So some international organizations like FIFA, for instance, also use Swiss Verein as the corporation that meets them together, though they are an association of independent football associations all over the world. So this is just to help you understand how law firms can grow to that kind of scale. So Skadden, Arps, Slaton, Mega, and Flom, number 6 on that list that we saw, was of course one of the law firms that represented Elon Musk in the Twitter litigation. I'm sure you're aware of when Elon Musk tried to buy Twitter and wanted to back out from the deal, and Twitter said, no, we are going to sue you, you must continue with the sale. So it just tells you that, like I said, some of these law firms are playing within these areas that were mentioned. Of course, Desmond, while taking us on Friday, mentioned the fact that Templars, a Nigerian law firm, was instrumental, or were the ones who represented Starlink, that's Elon Musk's company, in bringing the internet service called Starlink to Nigeria. So just thought to mention that as well. So emerging areas, I choose to define them as, a blue ocean strategy when you want to go into emerging areas. So emerging area gives us the opportunity to plumb the depths of blue oceans in legal practice. So the idea of blue ocean, I'm sure if you have read this book, or if you have not, then it's a good book to just get and read. It helps you from a business point of view to understand how to excel in a market that is crowded with competition. So the blue ocean strategy divides markets into red oceans and blue oceans. So red oceans are all the industries that we already know in existence. Those are industries that have developed, clearly defined boundaries and accepted competition, rules of competition. So for instance, an example in the legal sector would be elections litigation. We already know who the leading law firms in election litigation are. It's quite a defined field. It's, as a new entrant, you are up against a stiff curve to try to break into that market because the names are already well known and well established in that market. But in contrast, the blue ocean talks about an industry that is not fully yet formed, not yet fully in existence. It's an unknown market space where competition has not already become so stiff. So in blue oceans, demand is created rather than fought over. So you don't just go there to fight over, but you rather create your own demand, create your own pool of clients. So in a blue ocean, there's ample opportunity for growth, and it is, that, and you see that to be profitable and for rapid growth to happen in that market. So it's a good book to read, like I say, just to help broaden your horizon when you think of competition and how to carve a niche for yourself in this crowded legal space that we currently have in Nigeria. I mean, last elections, we had over 60,000 lawyers who had paid practicing fee and who were registered and eligible to vote. So it tells you how stiff the competition we are facing. And of course, every new year, just like you joined the profession last year, this year we expect maybe another 5, 6, maybe 7, maybe even 10,000 to join the profession. So in that kind of competitive space, you need to begin to think about how to carve a niche for yourself where you don't have, where the competition will not overshadow you. So what are some of these emerging areas? So the first thing we need to understand is that emerging areas of law typically converge around the emerging areas of value creation in society. So law naturally responds to protect value creation. So for instance, election petition in 1999, when Nigeria came back to democracy, a year before that, there were no elections being run. So there was really no value creation around litigating election matters. But in 1999, the moment the first elections were held and the constitution was in place, suddenly value was created in that space. So law responds to protecting the creation of value. So one way to know what the emerging areas of law are, or to begin to forecast what emerging areas you should begin to look forward to applying yourself to, is to follow the value, and that is simply follow the money. So where the money is going at the moment tells you where emerging areas are. So for instance, African Continental Free Trade Area Agreement has come into existence. Clearly, it tells you that there's going to be value around that as people want to begin to transact across African borders more effortlessly. So that's easily an emerging area that you could begin to think of applying yourself to. Of course, as we discuss further, I would give more guidelines on how to really audit and know where the law is headed. So for our purpose today, we're just focusing on 3 areas. Like I said, there are lots of areas, and my aim at the end of this this session today is to not just tell you where the new areas are, but to help you understand how by yourself to study your environment, study market around you, and discover yourself what are the new areas. For instance, election litigation, like I mentioned, might not be a new area anymore, but you could be in a unique position where for you, it can become a new area because of your location. For instance, maybe where you are based, there are not too many sound election litigation lawyers. It could be a new area for you. So the whole idea is knowing how to understand your environment, your circumstances, and knowing what areas you can make quick traction on. That can actually become your new area. But for general purposes, we're talking about intellectual property, entertainment, media and sports law, and technology and fintech law. These are very popular areas which personally I've benefited a lot from, and I believe any new wig like you can easily benefit from. So some of the advantages of practicing in emerging areas of law. Number one, what the important thing is, don't just jump into an area because it is trendy, sexy, looks glamorous. I mean, there was a time where maybe 2-3 years back, every young lawyer I met just say, I'm a fintech lawyer and all. Yeah, I mean, it's good too, but the truth is you need to understand that getting into an emerging area can also be tough work. It can be daunting work. It's not the fact that there's not much competition doesn't mean it's just easy for you to take, because sometimes, it's a long curve market. It takes a long while for all your efforts, your marketing, your branding and all to begin to pay back. So you need to understand this. Don't just jump in. Understand your context. Where am I based? What are the advantages I have relative to other lawyers who can also practice in this area, so that you leverage on that. You don't just jump in and say, because, entertainment law is the new thing. Whiskey and Nigeria is winning so many Grammys now, so I want to get into entertainment law. No, please study your own circumstances and be sure it is the best place for you. So there are a few words I mentioned in the last slide that I think it's important. Okay, well, I'll get to that. But as we mentioned earlier when we were talking about the blue ocean, the one advantage is that you play with less competition. So imagine if you set up a boutique elections litigation firm as a fresher in Abuja, where there are so many law firms already doing that. The chances that you will break into the market quickly is not much guaranteed, because you are up against really tough, high-level competition. But imagine if you set up an advisory. There are not too many fintech advisory firms in Abuja or in Lagos at the moment. Maybe they are in Lagos, maybe in Abuja already. But imagine if you are somewhere in Jos, in Kaduna, and all of that, you might stand out, some more. Of course, depending on whether the market there is enough to sustain you with clients who are interested in that kind of service. So another advantage is that other lawyers not specialized in this field can become a referral conduit for you. So personally, for instance, I benefit a lot from referral from other lawyers. You just say, Max, this is your intellectual property thing. Me, I don't really understand it. I have this client is complaining on this and that and that. What can you do for him? And that way you can see that people would normally have been competition and have rather become collaborators and are referring briefs to me. So standing yourself out in all these emerging areas quickly would make you, become the go-to person that other lawyers would come to. And of course, because it is unscripted territory, it means that you can create bespoke offerings and unlock greater value. So, for instance, one of the ways you can build clients in the fintech space, because of how the level of high growth those companies can get, you can say, look, rather than pay me all the money in cash, pay me in sweat equity. So sweat equity simply means that for the work I've done for you, advising you and helping your company get started up, rather than pay me a retainership fee or just pay me money, give me, X% equity in your company. I mean, of course, there are some ethical rules and conflict of interest issues around there. You have to be careful on how you do that. But essentially, being in these areas, since they are unscripted, gives you that room to, offer, bespoke services. I'll talk more about bespoke. You can also score international clients more easily by tapping into what we call the global skills arbitrage. I'll explain that in the next slide. But know that it might not be wise to jump in wholly without prior experience or having some more regular areas of practice that serve as your bread and butter. So, I mean, you can see, for instance, I do a lot of work in these emerging areas, but, I'm just coming from court this afternoon. So no matter what I do, I understand that, look, there's still the established areas of law. And what happens is that it becomes it becomes a positive feedback both ways. So as I get clients who practice who seek services in these emerging areas, they also sometimes have conventional legal needs that I can also meet in my regular everyday practice. So as I'm building expertise and experience in these emerging areas, I'm not abandoning the regular that has been there and has been my bread and butter also. So it's just good to have that balance. But sometimes if you are specialized enough or you have played enough in the industry, you can choose to say, look, I don't want to do anything regular. I want to do what we call a boutique law firm. I would only focus on this area. But rather, I'll just advise you that at this startup, keep a broad base. And then as you grow, and with more skills, more experience and all that, you can decide to focus on one area, but start with a broad base and then allow the times, focus you into one area. So I mentioned a few words I just want to talk about because these words are words you will hear a lot if you want to play in some of these emerging areas. So a boutique firm, for instance, also what we call a niche practice, is a law firm specializing only in a few specific areas of practice as opposed to what we call full service firm. So my firm, for instance, is a full service firm, but some law firms and some, in emerging areas, look, all we do is we just advise fintechs or we advise, creatives, so people in the entertainment industry and all of that. So usually boutique firms are not very large practices. They have limited headcount, but what they call boutique law firms in the US will blow your mind off. I think the US is saying for firms that are below 100 lawyers, so you can imagine in Nigeria for us, a firm with 100 lawyers is considered a big practice, but that just tells you of the different stories in the different markets. So bespoke is another word you hear a lot about. It just simply means tailor-made or personalized services. So, these are services that are flexible. So it could be things like service integration. So rather than just tell a client, I'm going to incorporate your company for you, why don't you integrate services? Incorporate the company, help them do their first tax clearance, help them get any operating licenses they need. If it's NAFDAC license they need and all of that. So you just bring all those bouquet of services and give them a one-stop shop experience. This allows you charge more and makes you give more value to the client. Then global skills arbitrage is something I'm very particular about, and I think a lot of young lawyers will need to take note of. Arbitrage as a word, and we'll talk more about it, is typically an exploitation of differences or gaps that exist in a system. So for instance, a good example is, in pricing or in laws and regulations. So if prices are higher in a particular place, the prices to sell goods are higher in a particular place, but buying those goods are cheaper in a particular place. So arbitrage, in a sense, is like buying from where prices are cheaper and selling where prices are higher. Now, that's a very loose definition of arbitrage, but when we talk about regulatory arbitrage, you get to understand it more. So skills arbitrage is the ability to offer skilled services to a higher priced market. So for instance, the US market pays a lot more for legal services, e.g. writing a letter of demand. You will be able to get more in the US than in Nigeria. So imagine if you reside in Nigeria where your cost of living is low, but you are able to work and charge and earn in dollars. That would be very good. And I'll talk about some of the platforms that help this. Now, what we call outsourcing and freelancing platforms, or what you could also call gig economy or Uberized platforms. So just like Uber, the way Uber works, that's how some of these platforms work. Somebody has a legal need, he comes on that platform, and then he's able to look for lawyers who are willing to offer that legal need, not just lawyers. Upwork and Fiverr, I've mentioned, have all kinds of services, but lawyers can also go up there. And some of the good work lawyers can do this. People just want somebody to write them a single letter. They can come there and ask for a lawyer to do that. So imagine you can be in Nigeria, nothing stops you from offering those services even to clients who are in the US. So what you're essentially doing is that you are, whilst being in Nigeria, taking advantage of the higher earning potential of markets that are outside of Nigeria. So it's something I think a lot of lawyers should pay attention to. So you can go up, my slides of course will be shared to you. You can go on these platforms and check them out. Create a profile for yourself and begin to learn how to market yourself on these platforms. You can be in Nigeria, earning money, doing simple work. Sometimes write a simple cease and desist letter, write a simple privacy notice, a simple agreement. Somebody wants to buy a car, just wants a lawyer to help him check that the agreement is okay. And the pay you might not be much, but because it comes in such convenience and the platform makes it easy, you can easily take this opportunity. So let's go to how to establish a practice in an emerging area. Let's look at trend spotting. So we need to know how to spot the trends and the evolutionary circles that produce emerging areas so that you can help us gain that first mover advantage. I've already mentioned a few of them. Look around you, law and economic policy. Like I said, follow the money essentially. Any new profitable societal endeavor would definitely bring legal challenges. Because once there's value, people are going to need lawyers to help them clarify, draw up agreements, resolve disputes, and all of that. So always look at new government policy, international economic events, evolution of science and technology also is also another thing that always brings value. So always watch out for those areas. That is where legal, emerging areas spring up. So also watch the competition, study the bigger law firms. What are they doing? Sometimes they can help you know where the market is headed. So you could easily go on their website, study their, what they write about themselves, study what they say about themselves on LinkedIn, for instance. It tells you easily where, because they might see further than you. They have analysts advising them. They have a longer reach. They're able to see where the market is headed. So sometimes you can, follow them, like we say in Nigeria, follow who knows. So you can follow them and get into some of those profitable areas. But however, the caution is avoid buzzwords and fads. Get solid value. Be careful. Don't get carried away by buzzwords. Seek out value by asking, what unique advantage can I take of this new phenomenon? It could be your location. It could be the fact that the people who play in that space, like fintech, a lot of them are in your generation. They are your friends. So they are more likely to retain you than to retain the older lawyers. It could be the fact that you have writing skills to do a lot of writing and market yourself on LinkedIn and on other social media platforms. So you need to understand and study all of that. So be adventurous and curious to study these things a little bit deeper. So for instance, one of the areas I'm currently beginning to gain a lot of experience and interest in is space law. So lately I've joined the space law group. I study a lot about space law. What is it all about? And you'll be shocked at how relevant what is happening in space is to our everyday life. We talked about Starlink, the internet service by Elon Musk. That actually is an expression of what space can do. So these are things that are practical, and you'll be shocked if you begin to study them some more, how relevant they are to you and how you can begin to get new briefs and open up new markets in these areas. So of course, take on some new briefs in these areas, even if it's going to be pro bono or low bono. Low bono simply means you are charging very low fees, or sometimes you take them on for what I call sweat equity. So you say, look, I know you don't have money to pay me now, but in return for doing this, I take shares in the company, or I take a stake in the business that is coming out of it as well. So what this will do for you is that you might not be paid, but you practice your skills. So for instance, when I was still much younger at the back, there's some clients I had who never paid me, but they were always tasking me to drop all kinds of agreements, exclusive distributorship agreements, joint venture agreements, shareholder agreements. So because of those guys, I really learned and honed my skills in those areas. So when the time came in future where I had clients who needed those services now, I had already learned. I didn't have to go and start learning all over anymore. So it was easy to just pick up some of those drafts, dust them up, tweak a few things, and the client will be impressed that, look, he needed the draft of a JV agreement, and in 3 hours, I had already sprung up a very detailed draft. That's because I already worked on it before. So sometimes just, don't allow money alone lead you, particularly if you have the time. Getting some of these things, just to be adventurous and to give yourself some practice upfront. So I want to just name drop a few of my friends who actually got into some of these areas that would seem like fad. Most people don't believe that blockchain, cryptocurrency, all that is real. But I can assure you that these two friends of mine have put up their screenshot of their LinkedIn profile. You should reach out to them, follow them on LinkedIn, and see what they are doing. I met them in 2016 when we came on a WhatsApp group called Law, Ethics, and Practice. And in that group, we began to discuss about blockchain, cryptocurrency, and all that in 2016. And today, Senator has gone so far. He's currently the president of Cyban. Cyban is stakeholders in Blockchain Association of Nigeria. He's doing wonderfully well in that area. Faith Obafemi also joined us on that group. Faith at that time was disillusioned as a young lawyer and just tired of law. She was not cut out for courtroom practice and all this litigation and all of that. She joined that group, and we continue discussing. Today, Faith is all over the world. I mean, she's currently doing a master's in a university in Amsterdam, and she's invited all over the world. She speaks about blockchain and decentralized technology. So it just tells you that there's solid value in this area, but you need to understand how to go after that value. Don't just go after fads. Don't just go after what is trending, but look out always for the solid value. So somebody like Faith, for instance, her strategy was writing. She was always writing articles and all, and that opened the door for her. Senator got into policy making, and that opened the door for him in the area of fintech, cryptocurrency, blockchain, and those emerging technologies. So what are the core of practice in emerging areas? So we need to just ask ourselves this question. I believe this question came up a lot during this month's session, and I heard also during some of the former sessions. So what is it really? Now, the truth is that emerging areas is a blend of old or general knowledge, new legal knowledge, and then general at least general industry knowledge of that industry. Sometimes you also need special or specific industry knowledge, but at least general industry knowledge is good enough. So a sound grasp of general knowledge gained from your LLB and your practice experience is, first of all, the basics. If you don't have this, getting into emerging areas is going to be a challenge because you are getting in there as a lawyer. So you need to have that basics in place first. Then you need to acquire new legal knowledge in that sector. So essentially, this is talking about the knowledge of the different areas or principles of law that govern that area. You need to be able to knit them together. So for instance, if you are going into entertainment law at its base has IP law, contract law, and then agency law. There are so many others. Employment law is also plays a huge part. But these three, for instance, if you really understand them, you're on your way to becoming an entertainment lawyer. You must know IP law, you must know contract law, you must know agency law, because these are three key principles of law that play in the entertainment law sector. So at least a general knowledge of that industry, you have to add it to the basics you already have, I've mentioned earlier. So you must at least know what's happening in that industry. Now, what you need to know most importantly is the revenue models. How is money made in this industry? You need to understand that. Secondly, you need to understand the risk profiles of that industry. How is money lost in this industry? If you know those two things, then you already have a general knowledge of that industry. Money in this industry, and what are the things we should watch out for to ensure they do not lose money in this industry. So if you understand that and you add it to your general legal knowledge and your advanced legal knowledge, you are on your way to becoming an expert in these emerging areas. So you might also proceed to acquire specialized industry knowledge if you want to become a thought leader in that sector. This is, however, not necessary, at least not at the beginning state, except you already have strong connections in that industry and you want to only focus your practice on that area. So sometimes also, please avoid becoming too specialist that you fight over granular industry matter with the player. So I've seen this practically where a lawyer is a fintech lawyer, and because he also knows how to code and do some tech work himself, he begins to argue with them about something. Sometimes, I don't know about it, but I always ask people, if a client comes to you and begins to impose his own opinion and says, look, Oga, what I want now is that you must get me an interlocutory injunction. I explain to him and say, Oga, yes, we can get an interlocutory injunction in this matter, but from my knowledge as a lawyer, it will delay the hearing of the matter. Let's forget about interlocutory injunction and proceed to hearing and get judgment quickly. So imagine if a client is imposing on you. That is what sometimes you do when, just because you think you have specialist knowledge, you begin to argue with industry players on their own field. Humor them. Let them know that, look, I have a general knowledge of this matter, but let them guide you while you advise them. But what you must always do is that make it clear to them that you understand the laws that regulate that industry very well. You might not know the nitty-gritty of how to code and all of that. So you can be a fintech lawyer without knowing how to code. That's the message essentially that we should take away from that. Avoid becoming too specialist, and then humor the industry players. Let them lead you on. Allow them feel like they are teaching you about their industry. But while you always make it clear to them that I understand the law that governs your industry. So acquiring knowledge. So I'll be looking at two things: online courses and books. But before I go that way, so the traditional way to acquire knowledge, of course, is by taking an LLM or the advanced course of study. We spoke extensively about LLMs. So that's one established way of gaining knowledge in these new areas. Another traditional source will be attending events such as the MBA conference, other MBA-related workshops, seminars like this handholding session, the ICLE events. Attend all of them. The MBSBL conference is also particularly attuned, or the MBSBL, as a whole, is particularly attuned to helping you, grow in this emerging area. So I would encourage you to join the MBSBL and at least join one or two of the committees of the MBSBL, because that is where you can gain a lot of knowledge. I'll put a link there, and like I said, this will be shared to you to become a member of the MBSBL. Registration is just 5,000 naira for you if you are below 7 years post-call. And to join, you get one free committee. You can get additional committees just for 2,000 naira. So some of the committees I believe be of interest to you. There's an ICT committee, banking, finance, and insolvency committee. They do a lot of work in the fintech space as well there. Intellectual property committee, sports, entertainment, and media, the young lawyers. So I would encourage you seriously to consider joining the SBL if you want to grow a practice in these emerging areas. So, however, a smarter and more sustainable way to get knowledge is online courses. Not everybody has the money to go abroad for, to some of the universities or even the Nigerian universities where these specialized courses are offered. So you need to be familiar with platforms like Coursera. Coursera is an online learning platform, what we call MOOC. That's a massive open online courses. X is another one. Udemy is also another one. Please Google these things, learn more about them. I believe a lot of you would already know about them. So I recommend a few courses that are personally taking that have helped me. So in intellectual property, for instance, one way you can become a credible IP expert is by taking some of the free courses available on the WIPO website. I'll put the link there. So one of them is what we call Primer on Intellectual Property. It's a very simple course, a general course on intellectual property. Then IP Panorama. I would encourage you, if you want to become an expert in IP, take this course. The course is practical. You learn the theory and the application of IP in industry. So if you take that course alone, believe you me, you are already an IP expert so far as I'm concerned. So I've taken a few books from my library that are on IP law, just to encourage you. These books are also very good. So there's of course, you are going to get the slides and you'll be able to check out these books. For sake of time, I'll run on quickly. Entertainment, Media, and Sports Law. The MDICLE already did a very great training on entertainment law. I encourage you to start there if you want to learn more about entertainment law. It's a 2-day training. I've put links to the YouTube MDA HQ YouTube where these videos can be found. You can start with those videos. It will give you a good grounding in entertainment law. There's also a very good book by Michael Dugeri, Entertainment Law in Nigeria. In fact, I told the author that this is not a book. This is an LLM. You actually package and call the book. The book is phenomenal. I can assure you, if you get that book, you're on your way to understanding the A to Z of entertainment, media, and sports law in Nigeria. Then in for technology and fintech, MBA ICLE has also done a great job. And I've put a link to that 3-day training there. You can go there and also look at that training. Then there are a few courses I took on Coursera in fintech, which have really helped me. Financial regulation in emerging markets and the rise of fintech companies offered by University of Cape Town, South Africa, private equity and venture capital. And the good thing in these courses are that they are flexible. They are free, but if you want to get a certificate, you pay, I think, $50 or something was what you pay then. And you could also apply for a scholarship. They would even allow you to do the courses for free and still get a certificate. Then I also took a couple of books from my library that are connected to my practice in fintech and technology law. I mean, of course, you see a few surprising books there. Cybercrime and the law. Yes, cybercrime is a huge area of technology law. Then you also see a book on anti-money laundering there and countering of terrorist financing. A huge part of the work I currently do in the tech space actually is helping fintech platforms review their KYC policy. That's know your customer policy based on anti-money laundering and countering financing of terrorism regulations of the CBN, and of course the new anti-money laundering act that was passed in May of 2022 as well. So there's a huge opportunity, and we'll talk more about some of that. So a brief overview of some of the emerging areas and the practice opportunities available in them. So IP or intellectual property are intangible legal rights conferred on persons engaged in promotional, creative, or inventive works, which entitles them to certain exclusive rights of control and exploitation. So essentially what I'm just saying is that these are intangible things you create, that the law gives you certain rights so that you control it. No other person can make money from them without your permission. So there are 4 primary types of intellectual property governed by acts of National Assembly in Nigeria. So copyright is a bundle of exclusive rights granted to authors or creators of works of human creative expression. So this would be things like novels, that's literary works, things like movies, music, and all of that. So the idea is that the law allows you to control and stop any other person from copying, distributing, reproducing, performing, or broadcasting those works without your permission. So of course, you can already see that there's a tie into entertainment law there. Then trademark is a protection granted to the distinctive symbols or marks. This could be the words, the name, the logo, or anything that you use to identify and differentiate your products from that of other businesses or undertakings in the market. So that's a trademark. Then patent. These are time limited, usually 20 years monopoly, granted to the inventor of new or improved solution to a technical problem. So that's the technical definition of what an invention is. It's a new and improved solution to a technical problem. But to qualify as a patent, it has to be novel. That means it has to be new, never used before anywhere in the world. It must disclose what's called an inventive step. That means it must be more than just the obvious conclusion that anybody in that area seeing that problem will arrive at. And then it has to have industry makes a patent. So the law gives you a 20-year monopoly. Nobody can use that invention without your permission. Then industrial design is the protection of any novel. In a novel, of course, it's all like I described earlier, that is new, not disclosed before. Aesthetic talks about visual appeal. That is how something looks and feels, and also any non-functional feature that is applied to a product and multiplied by industrial process. So industrial design simply is saying some products, sometimes two products have the same function, but one looks finer or feels better, or is more comfortable to use. So that's what we mean by aesthetic. So that unique feature that makes it look finer, makes it more attractive, makes it easier to use, the law allows you to protect it so that competitors don't simply take that, incorporate that feature into their own competing product and compete with you. So like I mentioned, these are the traditional IP types. There are other connected IP devices that you can also use to protect your intangible rights. This will include trade secrets and confidential information. What you call the thought of passing off is just similar to trademarks, but usually used to protect unregistered trademarks. Character merchandising, where people use famous people to market everyday products, like putting the face of Ronaldo on tea mugs, for instance. Image rights also, how famous people control how people can use their image, including their voice or any other thing connected to them, to market products. Geographic indications, which is a protection that stops people from claiming products, because some products actually have the uniqueness that they have because they come from a particular geographic location. So the idea is to stop people who are not within that geographic location from appropriating the goodwill. So for instance, typical example, Ijebu Gari, for instance, is a type of Gari, or Ofada rice, is a type of rice produced in a place called Ofada in Ogun State. So you don't want somebody in China now suddenly claiming that he's selling Ofada rice. He's misappropriating the goodwill of Ofada, a place in Nigeria. Then plant variety protection also is another type of IP right that has become law in Nigeria by the passing of the Plant Variety Protection Act in 2021, I believe. So intellectual property is also relevant in the following industries. In the pharmaceutical industry, a lot of what is done in the pharmaceutical industry depends on IP. So for instance, the name of drugs and the logo is protected by trademark. The drug chemical formulation that makes up drugs could be patent or trade secret. The shape and the packaging, sometimes of the drug itself, or of the tablet of the drug, could be protected by designs. Then, of course, traditional and Eastern medicine also could enjoy from geographic indications. So, for instance, Chinese ginseng tea, for instance, enjoys protection. So you cannot be in Nigeria and be producing something in Nigeria and call it Chinese ginseng tea. You are misappropriating the geographic indication of China in doing that. Then, of course, in entertainment, movies, films, and broadcasts are largely protected by copyright and trademarks. Video games, another surprising, very profitable area in entertainment law, largely depends on image rights. So there's some famous cases where the person who made the tattoos on LeBron James actually sued the maker of the video game, saying, look, even if you're going to put LeBron James in your video game, you don't have the right to take my tattoo that I put on him because I own the copyright to that tattoo. It's also an interesting case. Then in technology law, for instance, software, protecting software and licensing software is largely regulated by copyright law. Domain names, which is essentially the name of websites, is largely managed through the trademark system. Telecom services and ICT services depend a lot on patents and trade secrets. Then, of course, devices like mobile phones, laptops, and all that benefit a lot from patents and from designs. And then, of course, other products and services in the technology space also largely rely on trademark protection. So the kinds of briefs you expect in intellectual property field: basic registration of IP. So somebody wants to register his trademark or his patent, you should, that's something easy that, even as a new wig, you can easily learn how to do. So for instance, one hot tip is that NAFDAC mandates that you must have a trademark registration before NAFDAC registers your product. So that's one area where you can effectively market yourself to people who want to register NAFDAC products, to help them register their IP. So recorders simply means renewals and maintenance of IP portfolio. So trademarks, for instance, don't last forever. So when you register a trademark, it lasts in the first instance for 7 years. After then, if you want it to protection to continue, you have to renew it every interval of every 14 years. Same thing with patents. Patents, you have 20 years, but each year you must do annual renewal. So these are part of the services you can offer to clients. Search and trademark watch services. So after a person registers a trademark, he needs to police it. He needs to be sure nobody else is using it. So one way to do that is that every time a trademark journal comes out, you can buy a copy and look through for your clients to be sure that nobody's trying to register a trademark that is similar or confusingly similar to theirs. Then IP due diligence. So there's what we call freedom to cooperate opinion. Essentially, a foreign client typically wants to know that if I come to Nigeria and offer my services or my goods under this trademark, is there anything stopping me from using it? So it wants you to check if there's any existing trademark or trademark that is close to that name. He wants you to check within the Nigerian social context, is it a good word to use and all of that? Culturally, is it acceptable and all of that? Then, of course, you could also be an IP consultant and help to design brand or IP protection strategy. Then, of course, you could also play in IP disputes. So when a trademark is being registered, for instance, there's opportunity to represent a client in opposition proceedings, to oppose a registration of a new trademark and say, look, this trademark is confusingly similar to my client's existing trademark. Then, of course, general litigation for damages, injunctions, anti-pillar orders in the court to say, look, this man has infringed on my client's trademarks and want the court to restrain him and also award us damages. Then another important area is anti-counterfeiting. So clients would engage you to help them move against people who are selling fake look-alike products and or misappropriating their trademark and putting on the product. So this area, for instance, would even lead you into practicing, hardcore criminal law. So, for instance, I currently have a matter where I'm trying to get a fiat to act as private prosecutor to prosecute people who counterfeited, a client's product. So it's a wide area. That's what I'm just saying in essence. Then entertainment, media, and sports law. My time is almost winding up, so I'll try to wrap up so we can have enough time for questions. So entertainment media also covers a wide area, music and film law. So a lawyer's work in this area spans, getting licensing for of copyright of existing holders. Somebody's doing a movie, you need to get what you call a synchronization agreement, which is a license where a musician allows you to use his song as an accompanying soundtrack in a movie. So issues of distribution, financing is also a huge area in music and film law, and lots of practice opportunities are available there. Broadcast and media law. The very important area now that is heating up is what's called digital advertisement. So if you are somebody who follows the entertainment and media space, you'd have heard that the Advertising Registration Council of Nigeria is currently suing Facebook, that's Meta Platforms, for I think about 30 billion naira for digital ads that are streamed on Meta's platforms, Instagram, Facebook, and the rest to Nigeria without getting a license in Nigeria. So it's another hot area. Digital advertisement is a hot area for practice now. Social media, of course, is also another hot area. So YouTube and TikTok, for instance, have already disrupted established media broadcast establishments. So comedy skits, for instance, them, Sabinus and the rest of them, have become even more profitable than traditional genres like film and music. So, Sabinus and the rest are almost making more money than regular actors and music stars are making. Then gaming and esports is another huge area. Video games, mobile games have become a hot market. For instance, the first time I heard about this was in 2015 MBA conference. A law firm from the UK came, and what they specialized on, at that time, one of their specialist areas was representing people who developed mobile games. So one statistic they gave us that blew my mind was, if you know Candy Crush, the mobile game produced by a company called Kings, they said at the time, that was 2015 when they came, that company was grossing over $40 million daily, I believe, from that game alone, just from that game alone. So you can imagine how massive these areas have become. Then, of course, sports also. Traditional sports have been revolutionized by new revenue models, driven by, digital media, character merchandising. So people in sports no longer make money just from the sports or from ticket sales anymore. Make a lot of money from digital media, digital ads, and all of that. So some of the kind of briefs you should expect in this area includes company formation and corporate governance, incorporation of companies and general corporate matters, helping them change directors and all of that, IP registrations, licensing, so getting permission to use copyright trademarks and all of that, regulatory compliance, advert clearance with ACON and the Nigerian Film and Video Censors Board. Then of the agreements you will find, influencer agreement or digital marketing or brand endorsement agreement. So Sabinus wants to do something for Union Bank, for instance, there needs to be an agreement. And most of these influencers, to allow them promote your goods on Instagram and all that, you need to pay something. So there needs to be an agreement. Then a split sheet is also another very important agreement that we hear a lot about. So when you hear a feud between two artists, somebody featured another artist on his music and the person who's featured is complaining that he didn't get any money from it, it's because they didn't sign an agreement called a split sheet, which should have stated clearly how much each person would get from that collaboration. I believe I'm almost on my last slide. Yeah, so technology and fintech law is also another massive area. Covers telecoms and ICT, software and hardware, so frontier technology, artificial intelligence, robotics, and all of that, blockchain, cryptocurrency, and NFT, financial technology. So some of the briefs you should expect in this area, of course, company formation, corporate governance, incorporation, licensing and regulatory compliance. So a very important point there is that most fintech companies, because the whole business model of fintech is to avoid regulation as much as possible. So that's what we call regulatory arbitrage, to look for those, what we call loopholes and cracks in regulation, where they can operate their business without having to get some of those heavy licenses needed from CBN. So a lot of the money lending apps, for instance, use simply a money lender's license. But of course, the FCCPC has come up with a new regulation for online mobile money lending now. So, but essentially, a lot of advisory work comes in that area. Then, of course, funding, negotiation, and documentation. Most fintechs seek private equity because they usually will not be able to raise money from traditional markets. So that's another area you need to. And so essentially, the whole law about the Startup Act, for instance, comes into play there. You need to do a lot of advice. So the popular agreements you will find in this area, co-founder agreement, to just make it clear between two founders of a fintech service, who owns what and how can you exit and how can you come in and all of that. And investing agreement is another important agreement. It's an agreement that allows people to be potentially given a number of shares in a company, but they don't own all the shares immediately. The shares vest. That means they become the shares vest, incrementally. So if you stay with the company, you might be given 10% of the shares of the company, with the condition that you must remain as the chief technical officer, CTO of that company for 4 years. So for each year, you get 1/4 of those shares. So the first year, you get 2.5 of the shares, percent of the share of the equity in that company. If you stay for another year, you get another 2.55%. So it spreads out over time. So these are some of the popular agreements you find in that space. I'm well out of time, so I would end at this point, and I thank you. And of course, I look forward to your questions. I'm also anxious, like you are, to listen to my Lord Justice Dingba as he comes up shortly. So thank you, Mr. Chairman. I'm ready for questions.
Thank you very much, Max. You've done a brilliant job of it, I must say. I just have to make a few comments. So I'm happy that you talked about the evolving phase of a legal practice in Nigeria. I just want to say to the delegates that if you can see it, or if you can see your leaders or the leaders of an industry, you can overtake them. Max was kind enough to draw an analogy between where we are in other parts of the world and where we are in Nigeria today. I'll just say that the founders, most of the founders of the leading firms in Nigeria are still around. You can see them, they're everywhere. And so that means that we are still at a very evolving stage, and people shouldn't be intimidated or afraid of the market and should remain very competitive. Max also, I'm happy that he introduced you to a lot of books. We're knowledge merchants. All that we do is to trade knowledge, and so you must continue to study. And then I think that a lot of disruption in the world today, and Max has told you about it, a lot of emerging areas. I mean, I think the reason why we felt it was important to talk about emerging areas is that it gives you a very quick advantage and a quick entry into the market, into areas where more traditional practitioners might struggle, because again, the things are not contemporary to their own development and evolution as lawyers. So thank you very much, Max. I think we have 2 questions in the Q&A box. One of them is, could you please shed more light on the lawyer getting paid with stakes or equity in a company, and how that can be balanced without any issue of conflict of interest arising?
Okay, thank you, sir. So yeah, indeed, that's a good question. Like I mentioned in my presentation, yeah, if you are taking sweat equity as the lawyer to a business, of course, you have to be careful. Now, in the startup world, it is possible. I mean, of course, our rules, for instance, make it clear that amongst others, one of the billing methodologies permitted by the rules of professional conduct is contingency fee billing. So you can enter into an agreement with the client and enter into what essentially is a success fee. So based on the success of the endeavor you are taking out for the client, you get a percentage on that. So nothing stops you actually in law from also being an investor in a company that you're also the legal advisor to or the company secretary to. Of course, what matters is that depending on the sector in question, there might be heightened reporting requirements to clear out that conflict of interest, just to be sure. But it's possible. And a lot of times what happens is that when you take sweat equity in these fintech startups, when they get to maybe their first or second funding rounds, they could easily buy you out or convert your equity at that point to long-term stock. So, I mean, nothing in law, for instance, prevents directors or company secretaries from also owning shares in companies that they are. But however, you have to maintain those disclosure requirements, and sometimes you have to stay off decision-making because your stake is particularly in question in that decision-making. But yes, it's possible. There are rules around it, but however, those rules do not prevent you absolutely from taking sweat equity.
Thank you very much, Max. I think the second question is for us, talks about the link for joining the MBA section on legal practice. So, I mean, in the absence of any further questions, Max, on behalf of the MBA Institute of Continuing Legal Education, I must say a very big thank you to you. I always remind delegates of the fact that those colleagues who actually participate in these training events do it completely free and just with a mind to inspire colleagues and help in their career growth and development. And I must say a big, big thank you for a very well delivered, well thought out presentation. Thank you very much, Max.
Thank you very much, sir. So I'm just hanging on and anxious to hear my Lord. I mean, I'm here for that as well. So for that purpose, I'm also one of the attendees. Thank you, sir.
I trust you, Max. We all know you're a sponge. And that's why we always like you around. Thank you very much. So I'll now go to introduce my Lord, Justin Namdi-Bimwa. So I have the pleasure this afternoon of introducing to you one of the most erudite members of the judiciary in the world. Justice Namdi-Bimwa was admitted to the Nigerian Bar Association, Nigerian Bar in September 1999, and presently a judge of the Federal High Court, in which capacity he has adjudicated on a number of cases, both civil and criminal. He has also been a member of the Special Court of 4 judges considered for the trial of terrorism cases sitting in Kainji Military Facility, Niger State. Prior to his elevation to the bench on 2nd December 2015, he was a legal practitioner with a good understanding of various aspects of corporate, commercial, contentious and non-contentious, including the legal rules relating to mergers and acquisitions, M&A, finance, competition, taxation, and capital market securities regulation. He started his career in the tax legal services division of international consulting firm Arthur Andersen, now KPMG Nigeria, where he developed capacity on the operations of tax and investment laws. Namdi has had a stint in the academia, having taught company law, business law, and competition, antitrust law at the university in the United Kingdom, the University of West England, Bristol. Namdi was also a commercial litigator and was at various times a partner in 2 leading commercial law firms in Nigeria, Punuka Attorneys and Solicitors and Olaniwa Ajayi LP. Namdi consulted for various institutions, including the Bureau of Public Enterprise, BPE, the Federal Ministry of Industry, Trade and Investment, and international institutions such as Adam Smith International and Sana Consulting on the subject of competition law and policy in Nigeria. In 2007, he was a technical member of a team that redrafted a competition bill for the federal government of Nigeria through the BPE, which bill was finally enacted by the National Assembly in December 2018 at the Federal Competition and Consumer Protection Act. In 2013, also, Namdi was appointed by the Minister of Industry, Trade and Investment as a member of a government committee mandated to draft a competition consumer protection policy for Nigeria. Nnamdi creates time to exchange intellectual capacity even as a judge. He was the key speaker on the Commission Law and Policy at the 2006 annual conference of the Nigerian Bar Association in Port Harcourt, and continually delivered papers at the MBA section of Business Law annual conferences in 2008, 2009, 2010, 2011, 2012, 2013, 2016, and 2022, amongst others on subjects ranging from commission law to aviation law, mergers and acquisitions, capital market law, secured credits, some of which papers are available on the World Wide Web. Prior to elevation to the bench, Nnamdi was for 4 years the chairman of the Commission Law Committee section of Business Law of the Nigerian Bar Association. Nnamdi was recipient of numerous scholarships and awards, including the Shell Centenary British FCO Sheving Scholarship to the University of Oxford, DFID Scholarship to the University of Cambridge, amongst others. He's on the faculty and adjunct basis of the Interdisciplinary Center for Petroleum, Energy, Economic, and Law, University of Ibadan, Nigeria, since 2012, where he teaches Commission Law and Policy and is a senior visiting research fellow at the University of Reading, United Kingdom. It is my pleasure this afternoon to introduce my Lord, Justice Nnamdi Dimgba. My Lord.
Tabenda, you can hear me, can't you? Hello, can you hear me?
I can hear you, my Lord.
Okay, so thank you very much for the very generous reading of my profile. I'm wearing two glasses. I have two glasses. I wear one when I want to look nice. And when I remove it, I wear the other one that I wear when I want to roll my sleeve and to work very hard. That's one I used to read stuff. So I have been asked to speak on courtroom decorum and attributes of an excellent lawyer, and that's from the perspective of the bench, from what I see every day, interaction and observation of the counsel who appear before me in the courts that I preside over. I would like to just say, by way of introduction, that we all understand that and I'm sure that Max Ikombe did make reference to that, if not directly, indirectly or impliedly, in the course of his presentation, about how vast and large the legal market, legal profession is. Certainly, it's a multi-billion-dollar industry that is based on a combined global figure. And I think when you look at research, there's indication to the fact that the present value of the world legal market is about $860 billion, using 4.9% measurement from 2021 compound annual growth rate. So, but just as the legal industry is growing in terms of market value, that's also the way you have a lot of people entering into it. In England, I know all the time people get called to the bar or get admitted as solicitors. In the US, it's also the same thing. The different bars, like the New York bar, California bar, the different bars, they admit of people. So there's quite an influx of people in the legal industry. What it then means, therefore, is that for you to survive in that kind of environment, you have to clearly, distinguish yourself. It is like the story of several apples that you throw, all of them are green, and the one that has to stand out has to be one that has a different color from the rest. And that then takes us to the whole idea about this paper that we're discussing, which is what attributes does a lawyer need to have to be able or to make an attempt at distinguishing himself from the rest of the pack. First of all, we'll know that who a lawyer is. When we talk about lawyers, of course, we're trying to restrict ourselves to those who have been called to the bar, who have been granted license to practice in their jurisdictions. And that's why I was mentioning in England about those who have been called to the bar as barristers in the different for in any of the four units of court, and then the solicitors, and then the US and the Nigeria. Nigeria must be those who have been licensed, called to the bar as Supreme Court advocates or solicitors in Nigeria. But you need to understand that when you come to a particular market, legal market, any market at all, even if it's medicine. And I think a lawyer told this to me about sometime last week, a senior advocate. He said, it is true that the market has so many participants in it, but at the very top, there were very few. He said, we are very few, we, meaning them. He said, he told me at the very top that we are very few and we know ourselves. So how can an industry where you have like 20,000, 30,000 lawyers or more, and then once you mention someone's name at that level, people know, like if I say Tobenna, a region, people know, and of course I know Tobenna. Look at how vast, how big Nigeria is. But you mention a name, people know that. Or you mention Marx, because the reference is made to Marx, where he is a sponge who soaks in a lot of legal knowledge and spews that forth when you press it. So that's the way, and I think there are a number of attributes that make all these lawyers stand. People like Chief Gane for him, your blessed memory, Chief Rotimi Williams, Chief Michael Zekome, Chief Ololani Bekum, Professor Konsola Ajayi, Onyechi Bazoe, Tobenna, so many other people, Augustine Alege. There's something that makes them stand out. And these are the things that, those attributes that we're going to make reference to. I've tried to identify a number of them. One is the composure, which is the ability to be calm and in control of oneself. And many factors play a role here. First, composure begins with appearance, and this extends to personal cleanliness. The legal profession has designated a dress code. For the lawyer, you have your shirt, has to be white. Traditional setting like ours in Nigeria. Black trousers and skirt and a black suit jacket are done with the wig and gown and collarette and bib for those who are in the bar. You have to wear that, and it has to be sparkling clean. I've tried to make reference historically to trace even the history of the wig and gown and all of that by talking about how the British came to adopt the robe and the wigs in the 13th century. I don't think I need to render that here, but if you get hold of the paper that I've written for this purpose, which I'm going to share with organizers, they're going to distribute that to the participants, you can have a benefit of reading that. But what is important is that worn-out attires should be changed. Lawyers have to look very clean. They have to be very well composed. Just by looking at you, you have to earn respect just by mere look. There are people you look at and you fall in love instantly with them. And that's also the thing with us, who are judges. There's a way that a counsel will appear before you, the way he composes himself, the way he is dressed, his courage, all these things would win your heart. And I can tell you that will also have an impact in your evaluation of how the case is going to be. It is true that you have this saying, the judicial oath, that you have to dispense justice without fear or favor, affection and ill will. That's true. That's the way they write it. But the judges are human beings as well, and they also have emotions too. So someone who is likable is likable. All these things affect you, particularly in situations where it is borderline, where you don't know where to go, and there's a great deal of discretion to exercise. When I'm faced with that kind of situation where a matter could go either way based on the state of the law and the state of the evidence, there's always a tendency for you to move for you to resolve that doubt, that confusion you have as to where to go, in favor of someone who has made a very good appearance for you in terms of their composure and in terms of their dressing. Okay, so a lawyer must endeavor to carry himself with utmost respect and reverence. It is hard to command a level of respect from others when one has none for himself. So the way a lawyer works significantly explains his level of organization. Thus, these factors must be considered in a new Wigs determination to become excellent. The thing is that right from the very word go, you have to make a decision how you want to end, or how do you want to end, how do you want to go. You make that decision from the very beginning of joining the legal profession, and then you work towards it. Success is hardly an accident. It has to be properly choreographed, properly planned, and worked towards. The other attribute that I recorded is a good knowledge of the law. And I said that it is one thing to know the law, it's another thing to correctly and creatively apply the law. So to my mind, good knowledge of the law apply both ways, because it is not sufficient to know the facts and the ratio of the landmark case of like Madukola and Kendall that we talk about all the time. The relevant question is, to what extent can you distinguish it from cases with similar facts? A good lawyer always strives to find loopholes in a court decision, statutes, or law and use it to the client's benefit. Laws are made for humans, and it is the duty of lawyers as ministers in the temple of justice to understand the law and apply them creatively. This rule applies notwithstanding the place of a lawyer, either in dispute resolution or corporate practice. Wherever a lawyer finds himself, the major task is to solve problems, legal problems. That is where right application of the law to facts become necessary. Understand the substantive and procedural aspects of every law when solving clients' needs. It's a preventive mechanism to avoiding costly mistakes that may lead to the unenforceability of a contract or the court striking out a case for being improperly. So good knowledge of the law, that's an attribute that I recommend to all the lawyers who aspire to make a mark in the profession. The other attribute is research and analytical skills. That's very important. You know, the word research is derived when we prefix RE added to the word search. So research is to look for something that is either lost or was never had. Put together, research is a systematic investigation of materials and sources in order to establish facts and reach new conclusions. Research is carried out in law to acquire new knowledge. And like other disciplines, there are research techniques in law that help to reach the intended conclusion. A bad case may be won or lost based on the quality of research. An excellent lawyer must be dedicated to the study of law reports. They help to filter the white and black letters of the law as contained in statutes and subsidiary legislation. As Oliver Wendell Holmes stated in his postulation of Raleigh School of Law, that what the court says in respect of a given matter is the law and nothing more pretentious. As such, reading law reports is instrumental for an in-depth understanding of law. Research in legal practice may vary from legal academic research, where the doctrinal and non-doctrinal methodologies are used. In practice, it is sufficient to critically read and become abreast with the facts of every case. Having skills in analysis is important here, in the sense that the lawyer is able to sift the facts and take note of the material facts which may lead to the failure or success of the case. Not every fact is material. You have to look for the ones which are material to your case. As I tell people, even in adjudication, most times I get like, people say so many things and I get volume and volume of written material before me. But in court, for those who are familiar with my style of adjudication, I tend to just mind straight. Where is the marrow? I go straight for it. Sometimes I ask questions in court, 3 or 4 or 5 questions I will ask. And all I can just tell people is that, okay, come back in 3 days' time for judgment. And they're wondering, oh, how is it going to be able to achieve this with this volume of materials? It's simply because I'm looking for the facts which are material. I want to know what exactly is the material thing. Once I have those interactions in court, I'm able to establish that I know what to mine for in those materials to find it. So that's what I think is, and that comes by ability to research very well, and ability to analyze, very well. Okay, that's what I recommend to us. The other attribute, number 4, is the writing skills. Research and writing skills, they go together. One of the biggest tools of every excellent lawyer. Writing ordinarily follows research. It is expected that the lawyer begins to draft immediately after research and consultation with experts in different disciplines and area of law in question. This may be a contract document, legal opinion, final address, things originating process, things to write. In all of these, good writing skills are very crucial. Correct use of grammar, punctuation, illustrations, they're very necessary. For someone like me, those who work for me, they understand the kind of demands that I have in terms of being able to write very well. Once I see a bad writing, I spot it immediately. It's like a piece of plastic on the top of the swimming pool. And they wonder, how do I get that? And I tell people, I don't want to see lawyers who write for me as if like they're working in a post office in the village. I don't like that kind of thing. You know, you have to write very well. If you can write well as a lawyer, as a new lawyer, I can tell you you've solved 50% of your problem. If you have good writing skills, 50% of your problems have been solved, because good writing skills means you're able to argue things very well in a very written form, and that would win you mileage, okay? Number 5 attribute is good communication, oral and written, public and listening skills. Oral and written communication is important in day-to-day activities. An effective means to creatively and persuasively write or speak well is to cultivate a culture of reading. Judges are psychologically and intellectually inclined to read or listen to the polished spoken and written arguments of lawyers. It does not mean that the judge is biased, but it is somewhat natural and human to listen more to an effective speaker. Not only is good oral communication necessary for canvassing arguments in court, it is useful for relating with clients and people generally. In conferences, public speaking can be employed to champion an ambition or ideology. Every excellent lawyer must be accustomed to principles of effective oral written communication and public speaking to stand out. Also, it is important to imbibe a culture of listening to people. Listening to people is a means of communication. In other words, an excellent lawyer must know when to listen and when to talk. Listening effectively endears you to people. It is a way of getting facts that will help your case during client briefing. Without effective listening skills, some details may be lost, and this may lead to losing a case or going back to the client to ask for details of already narrated stories. Good communication, that one is very vital, as I said. What I also advise people is that you have to have a tone of voice, a style of presentation, you know, for courts and for public speaking than the one you have for when you're gisting with your friends. I tell people, you know, maybe like Tobin, some other people who have been exposed to, you know, foreign living. You know, sometimes when you're speaking, you know, publicly in court, that's the one you're going to switch on. And then because you then speak differently from other people. And when you speak like that, you know, that polished manner in court, the judge, you can see the judge lift his eyes to look at you 2 times because you're making a good impression. That's what I recommend. Try to learn, you know, good communications, okay? Orally and writing as well. The 6th attribute which I identified is leadership and logical thinking skills. Leadership is the ability to lead and influence people. Similar, logical thinking means a state of harmonious flow of thoughts. Thus, an excellent lawyer does not need to be the president of the Nigerian Bar Association to be called a leader. Any significant effort exerted to change the thought process, behavior, actions, or decisions of people can be correctly described as leadership. In law, that's what it is, because that's what you're doing. You're giving thought leadership because you're trying to convince people to follow your line of thought and to say things from your own perspective. Thought leadership for the new Wigs is a small yet big step towards becoming an excellent lawyer. In today's society, where the social media has formed over 90% as a means of information dissemination, interaction and communication all over the world, it is easier to become a thought leader in social, economic, and political affairs of people. Thus, as a young Whig, It is important to write about things that interest you, share your thoughts wherever necessary, share your wins. That is how you become relevant. And relevance arguably translates to excellence. The business of law sometimes moves in favor of a popularly known good lawyer. So there's a friend of mine, she's a popularly known good lawyer. I tell you, there's this friend of mine, I think Chief Michael Zakome, I tell him all the time, I say, Chief, you've done so well even in this administration. All the big cases, all the most difficult cases, they look for Chief Michael Zakome. Why do they do that? Sometimes they say, no, we want a lawyer, who is very well known, because we're not looking for someone who just knows black letter law alone. We're also looking for a lawyer who is very intuitive. There are some other skills that we need to be able to win this case. And that's because Michael Zakome has managed to sell himself so very well to the public, won a lot of popularity. That, of course, has translated to success economically in the practice of law. So I think that's also something which we also need to be very conscious of as new lawyers. So logical thinking is as well relevant, as a lawyer requires some level of logical and critical thinking, both inside and outside the courtroom. While at the firm and everywhere he finds himself, logical thinking is a tool for presentation of arguments in such a way that the court is attracted, able to follow and understand the arguments. It is as well makes the judge to have a good opinion of the lawyer. Does a logical argument presented by a particular lawyer more than once reduces the rating of the judge on the lawyer? In some cases, this may undesirably result to the lawyer losing the case. The court may not be able to understand the arguments of the lawyer and therefore give judgment ruling in favor of the other party. Logical thinking is important to every lawyer. The other attribute which I've written down, which I've noted, is number 7 as good judgment and decision-making. Good judgment and excellent decision-making is reflected on the letters of all court processes. It decimates confusion. On a careful reading of an affidavit or even the witness deposition, to say the least, a judge becomes aware of the level of good judgment and decision-making possessed by a lawyer. Practicing law requires more than the ability to write. In writing a contract, agreement, or drafting court processes, a lawyer must be firm in his choices on how he wants everything to go. After making the firm decision, it becomes easier to outline his argument and proper choice of words to reflect those plans. Good judgment is the ability to choose between alternatives. As a lawyer, how you are able to sieve from options and choose the right one with higher benefits is critical to your legal practice. It can never be learned hastily. It is a process that becomes more of a habit with the revolutionary movement of the earth around other planets' time. For good judgment, you also need to be very intuitive. That's very important. You have to look at the judge and see what he wants, see where he's going. There are times in my court when I'm asking questions and I tell people, when I ask those harmless questions, I'm not kidding. And anyone who understands my style, they know that most of the cases which I resolve turn around those questions which I've asked. Pay close attention and answer those questions. There are times when I'm pushing you and I'm raising concerns about a certain argument. If you're very intuitive, you know you have to withdraw the argument. There are times when I've told very big lawyers, I say, Chief, please, can you withdraw that argument? Can you withdraw that motion? And they withdraw it, and it makes a very good impression because they've formed a very good judgment of what the court wants. If they press on, they want to go ahead, unless there's a dynamite hidden within that motion, that process, that argument, which I'm urging them to withdraw, and they press on. If they press on with it, without being in tune to my suggestion, where my leading, that sometimes it can end up disastrously. So that's a question of the lawyer having a good sense of judgment, good sense of decision making. The other attribute which I've written down there as number 8 is tech savvy. So the practice of law is increasingly being affected by the rise in technological innovations, talking about artificial intelligence and self-automated processes of functioning in the law firm. We see ChatGPT. You see so many things. We see talk about Zoom. Like right now, we're having this conference by Zoom. We all seated at the comfort of our various offices and homes, and we all join in. So we're like more of in a virtual meeting room in one place, though in different places. So lawyer needs to be conscious of technology. Okay, you know that Legal Judy and Nigeria Week Law Report Online, Law Pavilion. You need to learn how to make use of all these electronic means of conducting legal research. The disruption occasioned by the COVID-19 pandemic, court sittings could be conducted online. I tell you, even as I'm seated here, I do a lot of my sittings, court hearings virtually. Anywhere I am, I'm in Australia, if I'm in Sydney, I sit from there. If I'm in Geneva, I sit from there. If I'm in England, I sit from there. If I'm in Dubai, I work from there. If I'm in England, wherever I am, I work from everywhere. If you ask people in my court in Oka, I spend more time away from the jurisdiction than I spend physically, but it doesn't affect my work. I work all the time, everywhere that I am. And that's because I'm able to leverage on technology to be able to do that. And that's what I think most lawyers need to do. Sometimes I feel quite amused when I see how lawyers are struggling to connect. We tell them join by Zoom, and they're not able to do that. So what we've done is to maybe tell them to gather in my court, in my jurisdiction, so that my registrar will then switch on the laptop, and then they all congregate around the laptop, and then they're able to conduct their cases virtually whenever I'm not around, and I'm more or less logging in from another part of the world. So I think being tech savvy is a must for us if we want to be lawyers of this 20th current century. The other attribute I've put down there is problem solving. And I said the work of a lawyer is to solve problems. Of course, legal problems, providing remedial solutions or preventing mistakes. There are various ways this can be explained, but that is not the essence of this paper. However, a lawyer must develop his problem-solving skill and groom it to become habitual and behavioral. This statement is supported by the fact that a lawyer at all his time of practice is engaged in solving problems. It could be likened to the job of a medical doctor whose job is to administer drugs to patients to heal their sicknesses, or an engineer who combines various chemicals to build houses, machines, or roads to make human life easier. The good thing is that the foregoing professions, and indeed all professions in the world, are regulated and subject to the compulsory services of those in the legal profession. Law is the superstructure upon which every organized and civilized society is built. Thus, it is critical that young Wigs and all lawyers begin to see themselves as solution providers, applying the law as medicine for all legal disease. This will increase the way lawyers see themselves and also positively impact the quality of services. Suffice to say that those who understand this secret find themselves building top-tier and mid-term law firms. Despite how the profession has grown with the yearly admission of new Wigs, the legal services sector is so vast to accommodate everyone and future lawyers in such a way that every lawyer is actively functional. That is how endowed the legal profession is. It is an oil well that can never run dry, provided every lawyer understands how to creatively fashion his tools to drill into it. The other skill that I did identify as number 10 is negotiation. Negotiation is a survivor skill. Non-lawyers require it too, but for lawyers, negotiation is twofold. Negotiation on behalf of clients and negotiation with clients. Understandably, Nigeria is a society where the value of the legal profession is still at the infancy, and more needs to be done to holistically and totally expose citizens to the importance of lawyers. And that may explain why avoidable mistakes end up inside courtrooms. Instead of involving a lawyer prior to a transaction, people prefer to save costs by doing things their own way. And thus it is instructive for lawyers to understand how best to negotiate with clients to aid them in all aspects of transactions. Strong negotiation skill is vital in convincing the client on why a particular sum should be paid for general or special retainerships. By extension, lawyers must utilize their negotiation skills in negotiating with third parties on their clients' behalf. So these are the attributes which I've tried to identify for for lawyers: negotiation, problem-solving skills, tech savvy, good judgment and decision-making, leadership and logical thinking skills, good communication in oral and written forms, public speaking and listening skills, writing skills, research and analytical skills, good knowledge of the law, and a good composure. These are all vital, 10 of them, which identified the lawyers' attributes the lawyers need to have. I then move on to the decorum, the way the lawyers have to be in the courts when they're before the court, courtroom decorum. And I say that there are things expected of a legal practitioner while appearing before a judge. All of these things are certainly captured with the concept courtroom decorum. And if you look at the rules of professional conduct for legal practitioners, rule number 36, it says that a lawyer shall be attired in a proper and dignified manner and shall not wear any apparel or ornament calculated to attract attention to himself. He must conduct himself with decency and decorum and observe the customs, conduct, and code of behavior of the court and custom of practice with respect to appearance, dress, manners, and courtesy. If you look at Rule 45 of the RPC, provides that except with the permission of the court, a lawyer appearing before a high court, court of appeal, or the Supreme Court shall do so in his robes. And robes in this context refer to barrister's wig, robe, wig, wing tip collar, and bands or collarette for female lawyers. I had spoken extensively on how lawyers should dress when I talked about composure as one of the attributes of every excellent lawyer, and I refer back to that. But I think in terms of the courtroom etiquette, there are a number of things which we expect. One is that every counsel appearing before the court should show respect to the court. It is expected that counsel stands on his feet when a judge is leaving or entering the courtroom, and also bow when the judge bows as a form of greeting and respect to people at the bar. Thus, respect for the bench extends to addressing the court with maximum reverence and talking only when a lawyer is allowed or signaled by the judge to talk. No lawyer is allowed to shout at a judge or engage in heated argument with counsel on the opposing side. It will amount to total disregard to the court to do that. Even in terms of virtual hearing, if a virtual hearing has been slated for 10 a.m., why should a judge court log in and be waiting for the lawyers to log in? That's not right at all. I think they had a hearing that was on Wednesday last week, when I logged in, and I was like there for like 5-10 minutes waiting for the other lawyers to log in, and I had to tell the registrar to chase them up. I mean, it was quite annoying, and I did tell them that I was quite infuriated by that, and I think it was very wrong. So respect for the court also goes across being able to be punctual and to log in situations where a virtual hearing has been slated, okay? Other thing in terms of etiquette is that you need to be silent during proceeding. Talking during court proceedings is against the etiquette of the courtroom. Talk only when the court requests you to, and avoid holding conversations with colleagues during proceedings. You know, some of you know, sometimes I see some of you just giggling among yourselves. Why are you giggling in court? And then there's, you have to also avoid destructive behaviors. Similarly, a lawyer and every person inside the court must keep the phone silent. For lawyers especially, it will be dishonorable to answer phone calls during proceedings. Rather, step out of the bar with permission of the court when your matter has not been called to answer the phone call. Also, eating inside the courtroom is destructive and disdainful even when the court is not sitting. Eating inside the court is not only inappropriate, it as well litters the premises of the court. Punctuality and timeliness, I have speaking about that anyway, when I was talking about the expectations that we have. Most courts are open at around 9 a.m. and some at 10 a.m. Nonetheless, basic courtroom decorum requires that counsel is seated at least 20 minutes to the beginning of proceedings. Timeliness assists to prevent hastiness and unpreparedness for business of the day. In the same way, counsel must endeavor to show up on the date adjourned for his case. Failure to do this may lead to the court striking out the case for want of diligent prosecution or the court giving judgment in default of appearance, as the case may be. Mine is that if you're punctual, you're seated there, you're composed, then you get ready for the battle. I told you that judges have different mannerisms or different styles of adjudication. Some judges will just sit down there and soak in everything you have to say. They won't say anything, then they will go and write a decision. There's some judges are actually engaging without descending into the arena. They ask questions, they ask you, what's this? Because by doing that, they're processing how the case is going to be. I am one of those judges. I don't just see it. I'm not like that. I have to ask questions. By asking those questions, I understand the case better. I can then adjourn for judgment very quickly. And that's why I tell you for my court, the people will tell you I get quite quick in the way that I write decisions. You can come today, I tell you, come next tomorrow, come in 3 weeks, in 4 days time for your judgment. You wonder how it's going to, because I would have made up my mind by those interactions in court. Then use proper description for the judicial office. It is important that the judge is correctly called by the proper pronoun. Judges in the High Court, Court of Appeal, and Supreme Court should be addressed as my lord or your lordship, while magistrates should be referred to as your worship. Okay? Of course, in Nigeria, there's this debate about whether you have to call female judges my lord as well instead of my lady. I think the jury is out. I don't want to get into that, but personally, even as a lawyer, I usually call female judges my lady, which is the way it is in England. But I understand, depending on the female judge that you see in Nigeria, it may well land you in trouble if you address them as my lady, because they say I'm Lord. There's no female in the bench or in the bar. So with the impact of the COVID-19, the business of law has changed significantly. By extension, court proceedings are now done virtually, which I said before, where necessary for convenience of parties, counsel and the judge. Thus, it is reasonable that courtroom decorum may change to accommodate the development, the integration of technology in legal proceedings. I think there's a guy called Brett who analyzed the concept of virtual sitting, and he proposed new courtroom etiquette. I don't think I would like to go into that, but I think all of those things are covered in the paper. If you get that, you can then look at that. Okay. So the conclusion is that law is a serious business that requires utmost dedication and commitment. One must be excellent and outstanding with the right knowledge and skill to sufficiently benefit from the huge yearly turnover of the legal services industry all over the globe, which currently stands at about $860 billion. And in the courtroom, the lawyer is expected to show utmost respect to the court, avoid destructive behavior, and be punctual at all times, both in virtual sittings and in physical sittings. All these put together, if we imbibe the attributes and observe the decorum that we've tried to identify and discourse, I think all this put together will make all these new wigs that we're sharing this afternoon with into excellent lawyers, different from the rest of the pack. Thank you for the opportunity.
My Lord, amazing, amazing. As usual, excellently delivered. I actually think that this is a session that we must replay for all lawyers in Nigeria. I think it's not just appropriate for the new way. Excellent delivery. I think just a simple way you talked about the skills that are required, comportment, presentation, research, analytical skills, good communication skills, writing skills, leadership, and logical thinking, good judgment and decision-making, negotiations, problem-solving, tech-savvy, all of that, brilliantly delivered, my Lord. And in terms of, I think there was just way too much there, and thank you very much. I'm going to look at the questions and see whether there are questions for you. Someone says, how may the court address the tendency of senior lawyers condescending to young lawyers during proceedings? I'm not quite sure I understand that.
What condescending means, yeah. Maybe what,
yes, in this context.
Like being rude to young lawyers, maybe that's what they're trying to say.
Indeed, my Lord. Do you have any perspective on that?
Yes, I do, because even for me, what I take it is that everybody who is in my court is my customer, you understand?
Yes.
So everybody who is in my court, both big lawyers, small lawyers, senior lawyers, young lawyers, as long as you've entered my courtroom virtually or physically, you're my customer, and I owe you a duty of protection. So one thing I don't tolerate is for a big lawyer to be rude to young lawyers. I don't like that at all. And I make that very clear. There are times I lose my temper. The few times I lose my temper is when I'm trying to protect, because one, I don't even like somebody who is being taken advantage of. I don't like that based on my personal philosophy. So a senior lawyers condescending, which is the language of the question, to young lawyers, it's not a good thing. I don't think every judge tolerates that anyway. So the assurance we give you is that you are all under the protection of the court. If you're in a court and you're feeling intimidated by the way the senior lawyer is addressing you, all you need to say to the court is that, my Lord, I hope I'm enjoying the protection of the court. That's a way or something way of inviting the court, the judge, to come to your rescue and call the senior lawyer to order. I mean, I do it all the time. Senior advocates are trying to bully someone and say, no, please, you can't do that in my court. I can't take it. So once they're coming, they know there are boundaries they cannot cross. Okay, but but it's like that everywhere. Even in England, you can't be rude to someone because they're younger than you or they're less privileged than you. That's not right at all. The more you are given, the more you're expected to be gracious and humble. That's the rule. It applies in courtroom sittings as well.
Thank you very much, my Lord. Someone just asked about whether we'll get a recorded version of the program. Well, I'll just answer that one very quickly. As the YouTube channel, MBA HQ, you can go there and get a recorded version or view the recorded version of the session. My Lord, the second question that I see is also, how may the underhanded tactics of obfuscation of facts by some lawyers be addressed?
This one is like, what do you obfuscation? You mean, let me just speak in Nigerian way. It's like wayo kind of trying to.
Apparently.
The way it goes, that's what I was telling you. I told you about my style that I ask questions, ask people who are familiar with my court. Anybody who is coming, they tell you, get ready. If you're going to just not do mass court, you have to be ready for battle, because I, very quiet, the way I speak quietly, I'll ask, what of this? What of that? What of that? There are times let me tell you something. There's a case I did when I was a judge newly, one of the first cases I did in Abuja, where someone came and said that I should set aside, nullify a judgment delivered by one of my senior judges. Then I was a vacation judge. That's when they bring all sorts of applications. And what was the problem? He said that the judgment which they obtained was different from CTC that they obtained was different from what they had in court. I don't know if you understand. He said that the judgment that they listened to in court, when they now went out, got the CTC, the CTC was not different from what. So they now said that the CTC was different from the judgment, and therefore
delivered.
I was just cracking my head. A thought just came to my mind immediately, and I asked them, okay. And he was a professor of law, a senior advocate who was championing that cause. These political cases. I said, wait, counsel, prof, please. By the way, did you conduct a search on the file of the court? That's what I asked him. Did you conduct a search on the file of the court? And he said, my lord, he said, he said, my lord, we didn't. That's the way he just tried to. And this question which I asked you was the decider in the case, in the judgment. Why? Because when I now wrote my judgment, I told him I cannot set aside this decision. They told me to set aside. The reason is this. You're saying that the CTC was different from the judgment. How did you come by the judgment? The judgment was what you saw the man reading in court, which you taped. But that's not the judgment. Judgment of the court is what is written down in the file of the court, isn't it? It's in the file. They write it. Some use longhand. They write their judgment in the file and read it. Then the secretary then types it. So, and this it is a certified true copy of the judgment, which is what is in the file, not really what was read. I don't know if you get, because somebody could start in the process of reading. So, but for you to say CTC is different from what the judgment was, you need to have done a search on the file to say this is the correct original judgment in the file. This wasn't done. So when I then gave a judgment and dismissed that case, the junior to the senior advocate said, my lord, the day when you asked that question, and when you asked us that question, the day of final hearing, when you said, Prof, did you conduct a search on the file? And we couldn't give any answer. That's when we knew we had lost this case. I've had some very senior lawyers who say, please, they tell their junior ones, take note, everything Justin Namdi says in court, take record of that so that we can pursue that immediately. Because those things look like if they're very harmless questions which he is asking, they're the ones we decide the case. So they can try to hide the facts, but end of the day, every dispute turns in a particular fact. They can confuse it, but the judge knows what he's looking for. So that why you were of doing a case, he doesn't cut it for me. If the man is trying to hide the fact, in your own papers, bring out what the facts are and tell the court this is what the real issue in controversy is. If the man is hiding the fact, are you hiding it as well? Is he telling you to join him in hiding it? If he's hiding the proper facts, why don't you unearth it before the judge? So, Ben, you understand my point?
Yes, my lord. Yes, my lord. Very well said, my lord. I mean, I think, as usual, you've done justice even to the questions that have been asked. And I mean, it's quite instructive that these questions are coming from new Wigs. But I think that people, of course, ask questions based on their experiences. And I'm happy that you've handled it that tactfully. And I just want to say that lawyers should also have expectations of the judges and try to, make their case before the judges, even when they see that things are going wrong, no matter how young one is appearing before a judge. But my lord, I think this is an absolutely brilliant presentation. I mean, when one is given a topic around the things that one does every day, it's sometimes difficult to articulate the thought process so logically that you're able to deliver a constructive. Yeah, we're going to say.
Let me just weigh in on this. Let me tell you a story about all the things I've mentioned, all those attributes which I spoke about. The way of good presentation, all of that.
Yes.
When of course, you know me right from school, the university school. The first time I entered the court to speak, I was already a doctor of law. I'm telling you, the first time I went into court, prove emotion, I was already a doctor of law because of the manner in which I studied.
Yes.
I know that I was supposed to go to court with it was Professor Ajayi. Then that was in 2006, when I finished my studies and came back to Nigeria. So at the last minute, Prof said something had happened. He wasn't going to go to Abuja again. Who are we appearing against? We're appearing against Professor Kasumu. Kasumu.
Yes.
I mean, the institution, masquerade when it comes to, I said, this one, I'm going to die today. So, and he had other people. So I thought, okay, if I got there, I was going to tell the the other senior advocate who were on the same side with us. No, you have different defendants. That is my first time, so that Prof doesn't chew me that day. So when I now got up and I made my presentation and I spoke, calm voice, my very first argument I've ever had in court as a lawyer. And it went very well. You know, those senior advocates came. It was against Kasumwe. Oh, well done, well done, well done, well done. So I said that I was no point in it was my first time, but I hadn't wanted to ask them to come to my head. Since it's gone very well, do I need to tell them? so that's the thing. If you just prepare your things very well, have a very good way of communicating, and it's going to take you so very far. People will even end up inflating your value, adding more to your value than what your value really is. So, but this is
my lord.
preparation, actually. You see.
Yeah. Thank you, my lord. I mean, I'm just
all of you. You're going to be fantastic people. I don't have any doubts about it. You know, practice makes perfect. Just set your minds on it. Set a goal for yourself, and you get there.
Thank you, my lord. I mean, I'm just looking at the comments from the chat box, and I'm quite excited by what I see. Somebody says, "Thank you so much, my lord, for this educative presentation. I am not a new wig, but for the want of increase, I listened in, and these sessions have been very impactful." Some other one said, "Thank you, my lord. I wish I had this presentation when I was a new wig. Much appreciated. We'll definitely make it a part of must listen to new wigs in our firm from now on." And some other person says that they cannot miss an opportunity to listen to my lord whenever. It says, "I'm not a new wig, but each time I have opportunity to listen to my lord, I don't miss it." You know, my lord, as you can see, this is a session for new wigs, but we have many Oliver Twists in our profession. We have many sponges. I'm one of them. I must say myself that whenever I have an opportunity to listen to you, I consider it a great privilege. And I must, on behalf of the delegates today and on behalf of the Nigerian Bar Association Institute of Continuing Legal Education, thank you. And say we're very grateful to you for the time and for imparting knowledge to us today. Thank you very much, my lord. And definitely we'll reach out to you very soon. And I'm sure you will oblige us. God bless you for all that you do for the legal profession in Nigeria. And we wish you the very best as you continue to champion the best of what we expect of our profession.
Thank you. Thank you. God bless you, everybody. Thank you.
And delegates, thank you very much for attending today. And we're grateful to you. We know it's a very interesting time for our country, and most people would rather sit back and watch what's going on with the elections, but you all decided to participate today. We close the training series tomorrow. We'll have Dr. Adioye Adefulu, who will be talking about growing a career in corporate practice in Nigeria. And then we have the chairman of the Young Lawyers Forum and the immediate past chairman of the Young Lawyers Forum, who will be taking you through what you need to do as young lawyers in Nigeria. Thank you very much for your kindness in attending, and God bless you all. Hope to see you again tomorrow.
Thank you, everybody. Okay. Bye-bye.